All right, good afternoon, everyone. I have just taken my mask off because it is a little bit difficult for you to all hear me if I'm speaking behind a mask. Good afternoon and welcome to the first of our DAP reform sessions. For those who don't know me, I'm Kathy Bonus. I'm the Chief Planning Advisor at the Department of Planning, Lands and Heritage. I'm joined in the room by David Caddy, Chair of the Planning Commission, Fiona Z and Cassie Barrow, who have both been working on DAP reforms. Before I start the presentation, I'd just like to acknowledge the traditional lands of the owners of the land on which we meet and pay my respects to elders past and present. I think everybody is in the room now. If I can just a bit of housekeeping before we start, if you could all just make sure your microphones are on mute. This session is being recorded, so it will be, I think we're going to post it online at a later point. And obviously microphones on mute just help with some of the quality of that recording. There will be a time at the end for questions. There's the chat function that you can ask questions during the session if you would like to do that. I'll do my best to get to questions at the end as we go. If we don't get to answer them all, I think that we're going to record the questions in any case and put up a FAQ type document on the website at the end as well. I think that's all the housekeeping that I have. Just a couple more people by the look of it. We're just going to let into the meeting. And given that it's 4:01 and I like to be on time, I think we'll make a start. So today's session, we're going to give you an overview of the proposed reforms to the Development Assessment Panel system. And we'll talk a little bit about what's in the regulations, the changes to the DAP regulations. You'll get some information on how to have your say during the consultation period. And as I said, if you've got any questions during the session, please feel free to type into the chat function. And if we have time, we'll go through those at the end. If we run out of time, then we'll certainly provide a written response to those questions through the online ability. So the action plan for planning reform, which was released in 2019 by the Minister, identifies 3 goals for the reform of the planning system. There's 19 reform initiatives that sit under those 3 goals, and 2 of those initiatives, being C7 and C8, specifically focus on reforms to improve the DAP system. I'll just pause while there's a couple of other people coming into the meeting by the look of it. As you're aware, there has recently been some reforms to the DAP systems. In April 2020, the number of panels was reduced from 9 down to 5. There were some initial process improvements. Let's wait for the chairman to use his mic. Initial process improvements were implemented to improve transparency and help provide consistency of information. And then in 2020, the Planning and Development Amendment Act introduced the ability for a special matters DAP to be created, and also for a DAP to be established for 1 or more districts, thereby setting up what we're going to be moving to the district DAP system. Those reforms in the Planning and Development Amendment Act have yet to be promulgated, and they rely on the changes to regulations, which is what we're talking to you about today. In May of 2021, the state government launched a consultation program to obtain feedback and comments for the next phase of planning reform, and it's been referred to by the Minister as Planning Reform Phase 2. During that process, we received 109 written submissions, and there was over 350 online surveys during the 3-month public consultation period. And during that period, the Minister's Parliamentary Secretary travelled around the state listening to a range of industry members, community members and local governments. And I joined her in a couple of those sessions. And also there were ability for people to come and make a comment in shopping centres, at community forums around the city as well. Issues raised out of that consultation, there were a few. There was certainly broad consensus that with regard to DAPs, that the value of opt-in monetary thresholds and removal of mandatory thresholds would provide more flexibility and choice for pathways. Local governments were very keen to ensure retention of local government or community representation on panels. And there was also the need to ensure that the Special Matters DAP satisfies its original objectives in determining significant development applications, and that there should be appropriate threshold criteria established to ensure that developments of state and regional significance were the ones that were actually captured in the Special Matters DAP threshold. All of that feedback has been reviewed for consideration as part of the DAP reforms, and it's probably fair to say the feedback didn't highlight anything particularly new in terms of needed reforms, but it certainly did confirm a number of the proposed changes that were under contemplation. So, some of the key reforms. The changes are shown on the screen, or the key changes are shown on the screen. The key one probably is reducing the number of panels, current panels, joint development assessment panels and local panels to 3, and they'll be referred to as district DAPs. The DAP regulations will also be supported by ministerial orders relating to the Special Matters DAP criteria. So in today's session, we'll go through some of the proposed changes to the DAPs, and then we'll specifically discuss the Special Matters DAP. And I am conscious in doing this that the changes were only released at the end of last week, and so it's probable that most people haven't really had a chance to read through all the material and get their heads around it, and I do encourage you to do so. There's a whole range of information online that you can have a look at. So we'll just go to the district DAP boundaries. You can see the proposed boundaries on the screen there. The 5 panels will be reduced down to 3. And the 3 district DAPs will be the Metropolitan Inner, the Metropolitan Outer and a Regional DAP. The 2 Metropolitan DAPs will essentially contain the local governments that sit within the Metropolitan and Peel region schemes areas. So the key change is to the Regional DAP, which is the existing Regional DAP excluding Waruna, which will move to the Metro Outer DAP. So we come to the thresholds now. You can see that there's no changes proposed to the minimum opt-in threshold, and this will stay at $2 million for all applications across the state. However, it is proposed to remove the mandatory thresholds. So that means the district DAP pathway will be entirely opt-in. And there was broad consensus across the phase 2 submissions that the removal of the mandatory thresholds would provide more flexibility and choice for determination pathways, would simplify the system and rationalise decision-making frameworks. So with regard to membership, it's proposed to appoint up to 5 permanent members to serve all panels across the state. However, the number of permanent positions will obviously be based on the number of applications that are received. DAP members will continue to be appointed by the Minister, and they will be employed by the department. That will be either on a part-time or a full-time basis. Essentially, being a DAP member will be their job. The presiding member and deputy presiding member must have a planning accreditation, and specialist members may also be employed on the same arrangement, so that for the 3rd specialist member on a panel, or they may continue to be drawn from a pool. The pool will be retained for use as it is needed, and that will include a situation where an alternative presiding or deputy presiding member is required due to their unavailability, periods of leave, illness, conflicts of interest and that sort of thing. And also may be of particular use in the regions, for example, to ensure that members have particular regional knowledge or experience. It's important to understand that there is no proposed change to local government membership or composition, and this responds to the feedback received from local governments regarding the representation on panels for local government and local communities. There are some exclusions to what can go to a district DAPs, and probably the most important one of those is that public works will be returned to the Commission. It's recommended that the Commission is best placed to deal with those, and where appropriate, it can also then review or extend its delegation of powers to achieve efficiencies in process, which cannot be done under the current system. And this is proposed to be clarified in changes to the regulations. So with regard to process, the general process for receiving, assessing and determining district DAP applications remains unchanged to the current system, and you can see that on the screen. Specifically, the department's role and local government's role remain unchanged, and the associated timeframes also remain unchanged. There are some improvements proposed for to improve transparency, consistency and effectiveness. Essentially, they are largely administrative, so the Department of Planning will provide additional administrative support, including hosting all meetings and taking minutes for all meetings. Meetings for district DAPs will be held at regular times, with the option to hold meetings outside of business hours where that's appropriate. All meetings will be made available virtually and will be recorded and published online. The regulations will also clarify that councils can delegate functions relating to RARs to staff, and if a council elects to delegate the responsible authority report to the Director of Planning or to the CEO, then the council would not need to endorse the RAR at a council meeting. And I understand there's been some confusion around that point. Administrative fees have been revised to reflect cost recovery rates for operations, and that includes the administrative component to process applications, coordinate meetings and provide support to panel members, and it also includes the payment of special members and local government members. The costs associated with assessment will continue to go to the local government, so the fees charged under the Planning and Development regulations will continue to apply. However, the presiding and deputy presiding members and any other DAP member who's employed on a permanent basis will be paid a salary according to their employment arrangement. We'll move now to Special Matters DAPs. I feel like I need to have a drink because my voice is going. Excuse me while I do that. The Special Matters DAP criteria process and decision-making panel was proposed to be created. The administrative framework will be established in the regulations. However, ministerial orders will be used to support those regulations. The ministerial orders specifically will establish the criteria for the Special Matters DAP to ensure flexibility and the ability for government to respond to matters of state or regional significance. In the consultation material are two sets of criteria. One is relating to projects of state and regional significance, and the other is relating to precincts of state or regional significance. If the project or precinct criteria is achieved, then the Special Matters DAP pathway will be mandatory. So as an applicant, your only option would be the Special Matters DAP pathway. The proposed project criteria is shown on the screen. Applications must achieve both the criteria and the value threshold. So, for example, a proposal for more than 100 multiple dwellings that achieves a value of $50 million or more. If the proposal didn't achieve that value threshold, it would not be eligible for assessment under the Special Matters DAP pathway. It could go through the district DAP pathway. State significant proposals under the lead agency framework, a value is not applicable in that process because the project has already been determined to be of state significance via another process. The lead agency framework focuses on providing major projects that are deemed state significant with additional state government support, such as through lead agency case management and cross-government coordination of approval processes. Those decisions are made internally within government through cabinet. So projects we see in the planning system are predominantly tourist oriented, but can include other types of proposals such as major infrastructure projects, renewable energy projects and so on. One example of a project that has been deemed state significant by this process is the Tawari Hot Springs proposal, which is an SDAU application currently in the system under Part 17. Also eligible for Special Matters DAP would be resource projects if they're not otherwise exempt, includes renewable energy projects, any associated worker accommodation. I think the other examples out there are probably fairly self-explanatory. With regard to precincts, you can see that proposed criteria on the screen. So the applications must be within the precinct area and achieve the criteria. For example, a proposal in the City of Perth for more than 51 dwellings and 5,000 square metres of commercial development would be eligible. Indicative boundary areas have been established with reference to the local planning framework, and preliminary engagement with the affected local governments has taken place to understand areas of significance. Indicative mapping of these areas will be available on the website and a precinct boundary clearly established. Metronet precincts already in a redevelopment area, or Metronet precincts that are already in a redevelopment area and covered by a redevelopment scheme. As mentioned, the precinct criteria will be established by ministerial orders, and that will allow for flexibility and efficient response to changing areas and matters of state or regional significance. Areas will most likely be those of high development pressure and or areas that are of importance to the state. A precinct may be established as a permanent precinct, or it may be established for a certain period of time, for example, for 5 years. Precinct criteria and project criteria can be changed at any time through a ministerial order in response to matters and places of significance to the state or regions. Now, there will be exclusions to the DAP system. Effectively, that's all applications that are currently excluded DAP proposals, and the new exemptions mentioned previously will also apply to special matters DAP. So that's up there on the screen for your information. The membership of Special Matters DAP. Now, Special Matters DAP will be very different to the district DAPs, and the proposed composition of the panel is shown on the screen. Key industry bodies, and government agencies will be requested to nominate around 4 to 5 people, and those members will then be appointed along with a deputy, and they'll be appointed by the Minister for Planning. So from the 4 or 5 nominations received from the nominators indicated, the Minister will then select 2. With regard to the last field, which is called Other, that may be a person with practical knowledge of and experience in one or more of the fields of property economics, commerce and industry, business management, financial management, engineering, surveying, valuation or transport. And potentially would be a nominee. Nominations for that area would come from one of the key industry bodies such as the Property Council, UDA, HIA or similar. I think the other bodies are fairly self-explanatory. The process for Special Matters DAP is different from district DAPs, and this process has been guided by the process that was undertaken for Part 17 development applications. So we've taken a lot of the learnings that we've had in Part 17 and applied it into the Special Matters DAP process. What is different though is that Special Matters DAPs will have a statutory time frame for determination, unlike Part 17. The time frame will be 120 days, which is the same approval that is used for the Redevelopment Authority, or now Development WA, but was MRA applications. The Department of Planning, Lands and Heritage will undertake the role of receiving, processing, assessing and coordinating referrals, and the department will also prepare the recommendation and the responsible authority report for the panel. Local governments will be referred the applications within their local government area and will be asked to provide comment. They will have 60 days to do this, and comments received will be given due regard. Local governments, however, will be responsible for the clearance of conditions and for ongoing compliance with a decision. With regards to fees, similar to the district DAPs, fees are established through Schedule 2 of the DAP regulations. The fees for Special Matters DAPs include the administrative costs, but also the costs associated with assessing, advertising and referring the applications and undertaking condition clearing and compliance. The department obviously can't levy fees under the planning and development regulations in the same way as local government can for assessment of planning applications. The cost for Special Matters DAP will also include fees to undertake initial design review and also for the payment of panel members. Again, the fees for Special Matters DAPs have been guided by the costs that are associated with the Part 17 development applications. With regard to the commencement of changes, it's something that I'm sure everybody is very keen to understand. Once consultation has closed, then the commencement will happen as soon as practicable. Once consultation has closed, there's obviously a number of things that need to happen. There's likely needing to be some modifications to regulations as a result of what comes out of the consultation, and there are also processes that need to be gone through for legal reasons and through Cabinet in order to gazette the regulations. Transitional arrangements will be really important, and transitional arrangements will be included in the final draft of the regulations. This may include a staggered introduction of the Special Matters DAP, and it may also include initially filling district DAPs from the specialist pool while their process to appoint members is undertaken. So the next steps. Consultation will conclude on the 22nd of April 2022. You are, of course, encouraged to review all of the information and to provide comments either through the online survey available on the department's consultation hub, or please send in your comments to the email address on the screen. Late submissions may not be accepted. Having said that, there will be the capacity for some things to be received a little bit after the date if that's unavoidable. If you do think that meeting that date is going to be a problem, could you please email the planning reform address as soon as you can, and please advise us of the date that you feel that you would be able to get your submission in by. We are aware that the 22nd of April does present some problems for local governments in particular with your council meeting schedules, so please let us know when after that date you feel that you could get your submission in. There are some links on the website, on the screen that take you to the website that will provide more information. There's various material that are up there to help you understand the changes proposed, and also the planning reform team is available to answer queries as well. Or to discuss the changes further. There's an email address up there. We do have a number of these information sessions scheduled over the next couple of days, and I think next week we've got some sessions that we're scheduling with some of the industry bodies. I know there's a session with Welga that's scheduled, I think towards the end of next week, a webinar. So please, if you have any questions, please send them through the chat screen now, or if you have any questions later, please feel free to contact us through that email address. And in the meantime, we will look forward to any comments and questions that you have.
Just got one on the screen, Kathy.
Just one. Does regional significance, I don't know whether I can read that without my glasses on.
I think it's refer.
Regional significance refer to
regions, or does it include sub-regions? In terms of state or region?
Oh, it really refers to regional areas, so of significance to the state or that particular region. So if I used an example of obviously statewide significance is quite clear, a major infrastructure project or something like that will obviously have significance to the state, whereas another project may be seen to have a particular significance for a region. If I take the Gascoyne region, a project in Carnarvon may not meet a criteria for a statewide significance, but may be particularly significant to the Gascoyne region. So in that case, the minister could determine that had regional significance. There are some more guidelines and criteria that are in the regulations and also in the Planning and Development Amendment Act, which will change the Planning and Development Act in that regard. Frequency of each DAP meeting and analysis of how many items could be considered at each meeting. Yes, we have. Thanks for the question, Pete. The district DAPs will meet on a regular basis. I'd like to say that we have determined roughly how many meetings that might be, and I would think from memory, and I am going by memory here because Fiona's going to look at me in a minute, is if the district DAP needs to meet on a fortnightly basis, then it will meet on a fortnightly basis as a regular meeting cycle. The intention is that it will be similar to a council meeting, so it would set a meeting cycle on an annual basis and then would either meet or would cancel the meeting if the meeting wasn't required. So it would be on a calendar that you could then calendarise. Are there any other questions? Is there any process to check? Checking if the development meets the $2 million threshold. That's always a tricky one. Generally speaking, it would be fair to say that there is no planning authority that I'm aware of that undertakes something that is like a quantity surveyor level check of the value of a development. However, if your development is looking like it's, might not quite make it, or you think that it could be not quite at the $2 million mark, then you'd be wise to put sufficient information into your application to demonstrate that it did. And certainly a planning authority does have the ability to require further information if they are of the view that perhaps your $2 million estimate of value might be a little bit optimistic. Will there be a limit to the number of items at each DAP meeting? At this stage, we have not thought about that. That is something that perhaps could form, you could perhaps let us know what your view is in terms of making a submission. Ideally, I think it would be fair to say that we would anticipate that, and if an application is ready to have a decision made, then it would be listed on an agenda. Having said that, the intention is also to ensure that the meetings are regular enough so that we don't end up with enormous agendas. And that, I think, is particularly going to be more of a problem with the metropolitan DAPs, possibly more than the regional ones. So if there's looking like a lot of applications needing to be determined, then would need to look at what that meeting cycle was, because perhaps the meeting cycle wouldn't have been set quite right. Are there any other questions? DAPs will be, as they are now, required to provide reasons for decisions that they make. So currently the DAP is required to provide a reason for its decision. The DAP will continue to be required to provide a reason for its decision, whether it supports a recommendation or doesn't support a recommendation. There's no change to that one. Okay, if there aren't any more questions, we might leave it there. As I said, there's an email address and there's plenty of material online, so very happy for you if you think of a question in half an hour's time to send an email in, and we'll certainly do our best to get a response back to you as soon as possible. I will say there may be some things that we may not be able to provide an exact response on now. That's one of the reasons why we do consultation, is because some of these processes, require your assistance in order to help develop them, particularly around the administration processes and what might work best. So please read the material. Please get in touch with us if you have any questions. Thank you very much for your time this afternoon, and enjoy the rest of your day.
Thank you.